Good morning, everyone. Thank you for joining us. It's good to be with you this morning. I'm Jason Cogdell. I'm one of two benefits attorneys for ProBenefits. Chris McCauley is here with me, and we're here to talk to you today about summary plan descriptions. So hope everyone is doing well there. Hope you're enjoying March Madness, and hope that at least some of you on the session today are somewhere that spring has actually started. As Chris and I are sitting here in our office in Winston-Salem, there is snow coming down outside the window, which is pretty incredible for March the 25th. So hopefully spring has found some of you, and hopefully it will find the rest of us soon. Today's session is our second session of our 2014 ProBenefits Client Webinar Series. Last month we did a special webinar on the new employer mandate guidance that was released by the IRS on February the 10th as part of our continuing healthcare reform education efforts. Today's session on SPDs, and next month we've got a kind of a unique session, a topic that we have not done before. We're trying to provide a good mix of general compliance topics and practical topics for you, as well as continuing healthcare reform updates. Next month's session, the April session, which is tentatively scheduled for April 22nd, but our invitation will come out later, is going to be about HSA eligibility, HSA bank account eligibility, and also how HRAs and deductible reimbursement plans work with HSAs and some creative plan design options for employers and advisors. So stay tuned for an invitation for that for next month. As far as this topic, the reason we wanted to talk about SPDs today is that even though there's so much going on around us with benefits compliance, thanks to healthcare reform and HIPAA changes and other items, sometimes it's important to get back to the basics. And today is a session about getting back to the basics, and specifically plan document basics, because plan documents for group benefit plans are some of the foundational requirements for benefit plans. It's really among the most important topics in employer-provided benefit compliance. So what we want to do today is briefly, and this isn't going to be a really long webinar, but we want to do a couple things. Number one, give you a refresher on basics of what SPDs are, what needs to be in them, what you need to know as an employer as these requirements relate to the benefit plans that you sponsor. And as listed on the screens there, we're going to talk about the SPDs for Section 125, which we assist many of you on the call today with, keeping your Section 125 plan compliant, whether that's a premium-only plan or POP, or whether that's a plan that has premiums and FSAs. I'm going to cover some of the SPD rules for ERISA plans, and also talk to you about what ERISA plans, including your group health insurance plan and other group insurance plans, need to have in terms of an SPD, what your wrap SPD options may be. And we also want to answer your questions. So you're welcome to submit a question anytime through the question box in the control panel, and we'll either get to those in the session, at the end of the session, or get back to you later. So Chris is with me. We're happy to be with you today, and thanks for joining us. Chris?
Thanks, Jason. And again, welcome to everyone out there. As he said, I hope you're staying warm. For those of us that used to live in the north and moved south, this weather is disappointing, but I guess I don't have to be distracted by any outdoor activities, and I can focus solely on the exciting topic of SPDs. So I guess we can jump right in. As all of you know, the IRS has told employers that they can offer tax-free benefits to their employees as long as the employers follow a set of legal requirements, and the most basic of those legal requirements is the written document requirement. And so that's what we're going to talk about today. That written requirement has two aspects, two different documents. The first is the plan document, and the second is the summary plan description. We're going to focus most of our discussion on the SPD, but I just wanted to touch briefly on the plan document. The purpose of the plan document is to basically set up the plan and show the IRS that, look, we employer do have a plan, and it is in writing, and it needs to be, the plan document is just the basic foundational document, and it needs to be adopted by the employer plan sponsor. That generally involves authorization by the board of directors or what other entity in your organization that serves the function of the board of directors. It also needs to be signed and kept on file with other important company documents. One question I'm often asked after sending out a plan document is, do I need to sign this and return it to you? Do I need to file it with a government agency? What do I need to do with it? And the answer to both of those questions is no. The most important thing you need to do with your plan document is to keep it on file. Although we at ProBenefits keep a copy of all the plan documents that we send out, the ultimate legal responsibility to provide and to produce the plan document lies with the plan itself. So keep that plan document on file with your other important company documents. Unlike the SPD, which we'll get into, the plan document generally is not required to be distributed to participants or updated with routine plan changes. I would say a majority of plans are using the same plan document that they have been using since the beginning of the plan, whether that be in 2011, 2008, 2003. Generally, the plan document is not updated with regularity and for the most part stays in place. The second aspect of the written plan requirements, or the second document, is the summary plan description. It serves a slightly different purpose than the plan document itself. The summary plan description, or the SPD, is designed to inform the employee of their rights and responsibilities under the plan. Because of that, there are some certain format and content requirements. The SPD needs to be written in plain language and designed for the participant's understanding. In addition, it cannot mislead the participant in any way and must also include any limits, exceptions, or restrictions to the plan. So it's important to provide this to your employees so that they understand their rights and responsibilities under the plan. It too should be kept on file by the employer and distributed to plan participants. The manner of distribution, there are several methods allowed by the IRS. They could be distributed by hard copy, whether that's hand delivery or in the mail, as well as electronic distribution in some circumstances if the DOL safe harbor for electronic distribution is met. And generally what that means is that electronic distribution, whether it be in an email attachment or on a company intranet, is allowable for employees that have ready access to computers at work. So for certain employers, the electronic distribution may work, and for other employers it may not work, just depending on the group of employees and whether they have ready access to computers at work. I'd like to say one other thing about hand delivery of a hard copy, and that is it's easy to make sure everyone gets a copy by hand delivery, but one thing it's not easy to necessarily do is to prove that you gave everyone a copy by hand delivery. So that's why sometimes some employers favor sending the SPD by mail, because it's easier to track the mailings rather than having to prove that you did in fact hand an employee an SPD if you were required in the future, either during an audit or some sort of lawsuit, that you might be required to prove that you actually did give the SPD. And finally, the SPD should be updated with material changes. Unlike the plan document, the summary plan description changes a little more often depending on any material changes to the plan, and we'll get into those in a few of the later slides. Okay, so let's jump into some of the content requirements for the written legal documents, and those content requirements are sometimes can be affected by the type of plan, but for all plans, the requirements must meet the IRS rules. Depending on whether the plan is ERISA or non-ERISA, I know Jason and I were talking prior to the webinar about how for non-ERISA plans, and by that I really only mean the premium-only 125 plan, or the POP, that perhaps the written requirements may be satisfied by just one document and wouldn't necessarily need a plan document and an SPD. However, customary practice has basically formed into the fact that two documents are now being provided. So even though a POP plan may be non-ERISA, generally there is a plan document and an SPD, which together satisfy the IRS content rules. And those content rules are governed by the IRS, and generally they involve basic plan issues which you would expect to be in the documents, including a description of available benefits, participation eligibility rules, or election procedures, manner of contribution, specifically salary reduction in most cases, and the plan year. So that's generally what needs to be in an SPD for any plan, because that's what's in the IRS rules. And so if a plan is an ERISA plan, and Jason will get into whether or not which plans are ERISA and not ERISA, but ERISA does have some additional requirements, content requirements, as you can see here, and he might jump back to this slide later, but there's a list of 33 additional requirements as well.
Thanks, Chris. A couple of questions coming in. One of the questions relates to where the employer's liability is, and specifically, one of the questions is, if the employer has an SPD but it doesn't distribute it, what would be a potential penalty to an employer for failure to distribute an SPD?
So generally, there really is no listed penalty for failure to distribute an SPD. Which is somewhat strange. However, there is a penalty if an employee requests an SPD and one is not provided within 30 days, then there would be a penalty of $110 per day for which that SPD was not provided. The employer has 30 days to provide the SPD to the employee after the request, and then any days after the 30 days that he or she is not provided to the employee, there's a $110 penalty.
Thanks, Chris. Another question relates to electronic distribution, and that question is, if the employer has employees with computer access, can they just post it on the intranet, or does the SPD actually need to be emailed to them or posted on some type of secure server? How the electronic distribution would work.
The intranet should be an acceptable method. However, the employee should be notified that the SPD is posted on the intranet, and they should be educated about the importance of the SPD, so that they know that going to the internet and actually getting the SPD is important for their knowledge of their rights and responsibilities under a plan. I know it's for a hard copy, just placing the SPD in a break room or a place that's frequented by employees is not fully compliant. And so it seems similar to an intranet, that not only should it be posted on the intranet, but also the employee should be informed that it's on the intranet, and also should be informed of the importance of that SPD. Okay, I think we can move along now. As you can see, the next slide, we're going to talk about Section 125 plans and what's important to having a compliant SPD that meets the IRS rules. So it's not only important that you have an SPD, it's also important that you're administering your plan in connection with that SPD. So there needs to be consistent administration between the plan and the SPD. One important aspect of consistent administration is updating your SPD every time there is a change, a material change to the plan. So if you're changing the way you administer your plan, you should also change the SPD as well to reflect that. And so I wanted to get into a couple of a couple of updates that we've been seeing for 2014 that are sort of prominent. This is by no means an exhaustive list of reasons you may need to update your SPD, but I just wanted to talk about some of the ones that are occurring quite often in the early stages of 2014. There are several employers that have had to change their plan year. They used to renew 1/1, but either for administrative reasons or cost reasons. I know there's a lot of issues with the Affordable Care Act now in 2014, and so some of those issues are starting to creep into the group health plans, and so it was either cost effective or administratively effective for the employer to change when their plan renewed. So many plans are changing either from a 1/1 to a 12/1, and some are actually changing from a 1/1 to a 4/1. There's all kinds of changes going on, but if your plan is changing plan years, it's important to amend your SPD to reflect the new plan year. So especially groups that are Section 125 plans with only a group health plan, it didn't necessarily get into their minds that they needed to actually make a change to the SPD. They went ahead and renewed 12/1, which was early, which was different than 1/1, which is in their SPD, and they didn't really think to change their SPD. So that's one potential reason, probably the biggest reason we're seeing changes to SPDs for early 2014. There's also the special qualifying event is another reason that we're seeing changes to SPDs, although we're sort of getting towards the end of it. Just a quick refresher, the special qualifying event is for non-calendar year plans that begin in 2013 and end in 2014 only. Those are the only plans that can take advantage of the special qualifying event. And basically what the special qualifying event says is the IRS is allowing a one-time change to allow employees to make a one-time change to their group health plan election. So whether they had coverage and they want to drop it or vice versa, the IRS is allowing a one-time change. And if your plan, it's completely up to the discretion of the plan whether to allow the change or not, which changes to allow, when to allow the changes. But if your plan has decided that, hey, we have one employee that might like to drop coverage and it wouldn't normally satisfy one of the normal qualifying events, but hey, the IRS is allowing a one-time change for non-calendar year plans this year, then maybe your plan would like to add the special qualifying event. That's another change that can be made to the SPD. Another important change is assessing the impact on the definition of spouse in your SPD after U.S. v. Windsor, where the Supreme Court essentially struck down the definition of spouse as between a man and a woman in DOMA, the Defense of Marriage Act, and that has had wide implications, and strangely enough it has crept into employee benefits, and so now employees do have the option to cover their same-sex spouse under their Section 125 plan and can pre-tax those premiums under the plan as well. The employer still has the option to define spouse however they want. Despite the ruling, I think it's important to note that the employer can still define spouse as between a man and a woman, but if they'd like to do so, they should do so and update the SPD and make sure that that spouse definition is consistent with the way they're administering their plans. Finally, there's several plans now implementing new benefit credits for the year, and those credits and however your plan plans to administer those credits should be implemented in the SPD. So those are just a few reasons. And then finally, maybe the biggest one, along with plan year changes, is the health FSA rollover. Again, just an update. On Halloween of last year, the IRS made a modification to the use or lose rule for health FSAs. No longer will employees lose all unused funds at the end of the plan year. but now they can roll over up to $500 of unused funds. And I know employers are using that to increase participation and tax savings, and so that's another reason that you may need to update your SPD during this time.
Thanks, Chris. We got a few different questions here. I'm just going to hit a couple of quick ones, and we'll try to cover any others we can get to, time permitting, at the end. First of all, a few of you have asked about the slides, which we will be providing, and we will have a recorded copy of this session in case it would be helpful to a member of your team or staff. Chris, one of the questions says, if we did the early renewal, let's say we were, I think in this example, the person used 1/1. It was a 1/1 plan. They renewed early for 12/1 for their health insurance. And dental, and I assume other benefits either went to 12/1 or will go this year. But the FSA, health FSA, was on a 1/1 basis and was not changed. And the question is, how should that be documented, and what would we recommend as far as the FSA plan year?
In terms of documentation, the SPD should reflect exactly how you're administering the plan year. So if the group health and the FSA are renewing on different dates, that should be documented in the SPD. Although we do recommend that the FSA eventually line back up and have the same plan year with the group health plan. I think having different plan years, especially between the group health plan and the FSA plan year, could cause problems down the road if, say, your plan wants to allow employees to make contributions to an HSA or switching from an FSA to an HSA or using them in conjunction somehow, whether it be a limited FSA. But there could be some problems if the plan years don't align, because a general purpose FSA and an HSA are not really compatible for compliance purposes. An employee cannot participate in both at the same time, so it causes some problems if the plan years are not aligned, if that change wants to be made by the employer. Thanks,
Chris. And also, really briefly, as a best practice tip before I go into ERISA, some of the common questions that we get from employers relate to Section 125 plans. For instance, a Section 125 plan, as Chris has described, is a flex plan, or also known as a cafeteria plan. That plan can be as basic as a plan that has only pre-tax premiums, or that plan could have pre-tax premiums plus health FSA, dependent care FSA, allow for HSA contributions to a bank account, allow for benefit credits, but it's all one plan. So we get questions from employers sometimes that say, hey, I've got one premium 125 document and a separate SPD document for FSA. I mean, really, this is one plan under Section 125. So, I mean, our best practice advice is have one good, solid, compliant Section 125 document that includes premiums, and if you have FSAs, they're included, so that you've only got one document to keep up with, you've only got one document to update, and you've got one plan that accurately and correctly reflects the pre-tax deductions that you allow your employees to have for these various benefits. The Section 125 document is essential for every employer, except for the 0.001% of American employers that don't have a 125 plan and don't use pre-tax deductions for employees. Every employer needs a compliant, updated Section 125 SPD, and that really can't be stressed enough. A second quick point as I move forward, we've gotten tried to answer a couple questions to the full audience, so if you look in your question box, you should see some question and answers to a couple of common questions there, and I'll try to do that as we go for some other common questions. I did want to get into ERISA, and I'm not going to go heavy into ERISA today, but I wanted to give you an idea of how ERISA affects SPDs. Simply put, as Chris said earlier, if a plan is subject to ERISA, it needs to not only meet the basic rules that Chris talked about, but there's some additional rules and content requirements for ERISA benefits. Now, first of all, what benefits are subject to ERISA? Here is the majority of the list on the screen here. If it's an insurance benefit like health insurance, dental insurance, life, disability, those benefits are subject to ERISA. Any group-sponsored insured benefit is subject to ERISA. Health FSAs are subject to ERISA. HRAs and deductible reimbursement plans are subject to ERISA. Wellness plans and EAPs are subject to ERISA if medical benefits are provided. So those would be benefit programs that you may not have considered ERISA for, that if medical benefits are provided, ERISA applies, and that would mean that an SPD would be needed for those plans that meets content requirements. Business travel, accident insurance, hospital indemnity coverage, those are examples of ERISA benefits, which are typically group-sponsored benefits that provide health, accident, or other welfare coverage. Now I'm going to skip back a couple of slides to the bottom of the slide that Chris covered earlier to say that ERISA says that there must be an SPD, and as Chris said, it must be distributed to employees, and he did a good job of covering that. ERISA also says this, whereas a non-ERISA plan, such as a pre-tax premium plan, can have kind of a basic document that just kind of explains the plan and what are eligible benefits, an ERISA SPD has to meet a detailed list, statutory list of 33 required items that must be in the SPD. There are a couple of examples: identifying the plan administrator, who is the fiduciary of the plan, the claims and appeals language. There must be a formal ERISA plan name and plan number and plan year. I'm going to show you and pull up the list of 33, and hopefully that's on your screen now. This is a list. This probably looks a little blurry on the screen. I'm just going to scroll down. This is the list of 33. I'm not going to go through them all now in the interest of time. If you would like a copy of the list of 33, we'll be happy to provide you. But you can see that this is a definitive list that must be included. I'm back up to the top now. These are the 33 items that start as simple as what's the name of the plan, the name of the plan sponsor or employer, the tax identification number, the type of plan, type of administration, plan fiduciary. Those are some sample items. A couple of you have already buzzed in and said you'd like a copy. So I'll tell you what, we will include the list of 33 when we send you the slides. But know that there is a list of 33 items. That's one thing that separates an ERISA plan from a standard benefit plan that's not subject to ERISA in terms of what may be included. Now I'm going to go back forward. Now once a plan is subject to ERISA, let's just, for purposes of simplicity, look at the group health plan, group health insurance plan that your company sponsors. Whether it's fully insured or self-funded, you've got a health insurance plan for your people. It is subject to ERISA. There must be a plan document. As Chris said, there must be an SPD. The SPD must have 33 required items. It must be kept up to date, distributed to employees. When do we have to distribute it? There are specific timelines under ERISA that say that new enrollees must get an SPD within 90 days. Anytime the plan is amended, participants must get an updated SPD within 210 days, and there's a 5-year outside limit that if anything changes about the plan within 5 years, an employer has not provided an updated SPD, they must provide it no later than 5 years from that time. Now, here's the question. This is a common question. We've got a fully insured health insurance plan. We don't know what our plan document is. We don't know what our SPD is. What's the answer to that? The default plan document, if you don't know what your plan document is, would be your insurance contract with the carrier if you're a fully insured plan. Your default SPD, if you don't know what your SPD is for your group health insurance plan, would be the participant booklet that the carrier provides on an annual basis, the insurance booklet or the certificate, as some carriers still call it. Now, in the not too distant past, that insurance booklet was provided, and I'm envisioning right now, the booklet that had Big Blue written on it from Blue Cross in North Carolina that we got ourselves. That was prepared by the carrier, sent to the broker or the employer, handed out, and so all the employees had this stack of paper, including the big booklet. Most of the time, the carriers are not providing it in hard copy now. They're just posting it on their website. So a key question is that effective distribution? I think the basic answer to that is no. That's not basic distribution, that the employer needs to take a further active step to make sure the participants have knowledge and easy access to the carrier booklet. But if nothing else has been done, those would be the default plan document, again, the insurance contract with the carrier, and SPD, the participant booklet. Now, next question, does that participant booklet satisfy the 33 items? The answer to that is no. Most of the time, good carriers like Blue Cross and United and Coventry and the carriers that you all work with have good, solid booklets, and they may even include most of the 33. The average is probably in the range of 25 to 28 items of the 33 that the carrier booklet includes. That is where the term WRAP SPD, wraparound SPD, was first coined, because a WRAP SPD is a separate, short, simple legal document that is designed to be built on top of the carrier booklet and fill in the gaps. And as listed under the third bullet point on the slide there in front of us, the first and most basic purpose of a wraparound SPD, WRAP SPD, is to supplement the carrier booklet so that all 33 items are included. Now, most of the time, the items that the carrier booklet is missing are very simple. You know, who's the plan administrator? What are the specific eligibility requirements? What is the plan year? You know, those types. A lot of the things are very simple. Sometimes they're more complex and maybe relate to a recent federal law, Women's Health and Cancer Act, or some other federal law that has been passed but has not yet been put into the carrier booklet. So the first, and when you hear WRAP SPD, the most basic purpose is to supplement the carrier booklet so that the carrier booklet plus the WRAP SPD equals a compliant SPD. Now, do most employers use a WRAP? No, most do not. Specifically, small groups do not. It's somewhat unusual in a small group setting for there to be a WRAP SPD, but that is absolutely a best practice, that an employer use a WRAP SPD to supplement a group health, group dental, group life, disability, etc. booklet so that it's compliant. If you're an employer that's very compliance conscious and you want to have all your I's dotted and T's crossed, you'll want to consider WRAP SPD. A lot of larger employers do have WRAP SPDs, in part because employers with over 100 participants in their plans file 5500s, and it's very important that the SPD be consistent with the Form 5500 filing. Let me give you an example. As listed on the third bullet point there, the second purpose of a WRAP SPD is to combine multiple plans. Let me give you an example of an employer who files one 5500 for 6 benefits, but there's no WRAP SPD for one plan or multiple plans. Well, that employer is out of compliance, because that employer, by filing one 5500, has essentially communicated to the Department of Labor that they have a WRAP SPD that not only supplements the booklets, but merges all 6 plans together for purposes of ERISA. If that employer files a single 5500 but doesn't have a WRAP SPD in place, they're out of compliance. Similarly, if an employer did have a WRAP SPD in place that combines all benefits, but they're filing multiple 5500s for those benefits, one for medical, one for dental, one for life, one for disability, then that employer has 5500s that are not consistent with its SPDs, and that's not a compliant structure. So it's very important that they be consistent. Now, is it required that a large employer or any employer combine multiple plans in the SPD? No, it's not. This is just a matter of simplicity. Some employers want to have one WRAP SPD for multiple plans so that there's only one WRAP, you know, for simplicity, and then number 2, so they can file only one 5500. That's more of a concern for over 100 groups than under 100 groups who don't have to file 5500s, but the same analysis applies. Now I'm going to not drop off the slides again to pull up a sample. One of the common questions we get, can we see a sample WRAP SPD? And I hope that Word document has popped up on your screen. What's on your screen right now is a sample WRAP SPD. This one is designed just for a group health plan, not to merge all the plans together, which is often called a consolidated WRAP SPD, or the new terminology is omnibus SPD. This is just a simple wrap around the group health plan. This employer had a group health plan booklet from United, decided that it wanted to make sure it was compliant, so they implemented a WRAP SPD to supplement the United booklet so that both documents together would be a compliant SPD. I'm just going to scroll down here. You'll see this sample company is in Raleigh. They've named the plan fiduciary. They've referenced United, saying that United is our carrier. We've got a booklet from United, and so this document incorporates the United booklet so that this document stands on top of the United booklet and fills in the gaps. I'm just continuing to scroll down here. You'll see, you know, this is just pretty basic information. Now we get into eligibility. One of the reasons this group did a WRAP, I'm going to highlight this on the screen, is that they had implemented a spousal eligibility rule, that they said that spouses are not eligible if they have other group coverage through another employer. The booklet did not have that. So if they wanted to enforce a spousal eligibility rule, they needed a WRAP document that included it, so that they would not administer the plan inconsistently with the SPD. This is one of the reasons this group did the WRAP. The WRAP is a perfect opportunity to not only fill in the gaps, but include any plan specifics or unique items that might not be in the booklet. I'm just going to keep scrolling down. This document is only, I think, 7 pages as we get to the end of it. Yeah, it looks like it goes on just onto the 8th page. But again, this is a fairly simple document. It's not written in incredibly complicated language. I'm scrolling back to the top. But I wanted you to see what a sample WRAP SPD is. A sample consolidated WRAP SPD or omnibus WRAP would look just like this, but instead of it being group health plan, it would say welfare benefits plan, and instead of just referencing United, it would reference United and the other carriers and all of the benefits, the ERISA benefits that employer sponsored. So that just want to show you a sample. I thought that might be helpful to look at that sample as what an SPD is. In the interest of time, I'm not going to dig deeper. I do think we'll probably have a more in-depth ERISA session sometime later in the year. This is one of the common topics that we present on, Chris and I present on for employers and associations and groups of plan advisors, because ERISA is so important and critical, and I think the overall level of understanding about ERISA in the marketplace is fairly low relative to the importance of the law. And so just wanted to bring those to your attention. Secondly, we do a lot of Form 5500 advising and a lot of 5500 work for large employers. If you have a need in that area, we'll be happy to discuss with you. But we have an annual Form 5500 webinar every May since the calendar year Form 5500 deadline is at the end of July. And we will be having that as our May webinar, just an update on Form 5500s, which includes, some of these crossover topics relating to WRAP SPDs. One good question: what does ERISA stand for? I could have mentioned that earlier. That probably would have been helpful. ERISA stands for the Employee Retirement Income and Security Act of 1976. ERISA is the primary law that governs employee benefits. It applies to retirement plans, which is outside the scope of what we do, but it also applies to health and welfare plans, as in this context. I have a colleague in Kansas City and an excellent benefits attorney who loves to say the E in ERISA does not stand for employer, it stands for employee. Translation, any conflict will be resolved in favor of the employee participant, and so employers need to know the law, need to follow the law to prevent any potential liability, whether it's regarding documents or Form 5500s or claim and appeals or plan, fiduciary responsibility. Those are all very, very important items. Chris, I'm going to take a quick look at some of the questions here if you'll cover some practical steps for these groups.
Yeah, no problem. I think we just wanted to put up a couple steps that that employers can take here at the beginning of 2014 that are very simple, very easy, and will either ensure that your plan is in compliance or at least let you know that, hey, maybe we need to do some things to work towards getting our plan legal documents in compliance. And I think the first thing you want to think about is what Jason touched on, just determining which plans exactly need documents, which ones are sponsored by the company and may need a plan document and an SPD which is compliant with ERISA. So the first question is to ask yourself, if you had to produce your current SPD for all plans, either for a voluntary or required audit, would you be able to do so? I think sometimes some people don't really understand the importance of the SPD or think it's not quite as important as some of the other compliance issues. But if being able to produce an SPD when required is just something very basic, it's basically compliance 101. So even if you don't think it's the most important thing, we certainly do think it's important to have an SPD, and it's also easy, and it's something to show that, hey, look, we've taken the first step towards compliance. It's certainly basic. So are you able to provide an SPD? And so if you ask yourself that, and then go ahead and make sure that you can confirm that you have an SPD in place for your Section 125 plans in order to protect your tax deductions for both the employer and the employee. That's very important. That's one reason you need an SPD, and also to to make sure you're in compliance with ERISA, so confirm the status of the SPD for your ERISA plans. And a best practice is to sort of look at your Form 5500 requirement and your filings of the 5500 and just confirm that those filings are consistent with the SPDs that you have in place. So I think as we move on in 2014, compliance is really at the forefront for a lot of employers, and a lot of that has to do with the Affordable Care Act and a lot of those changes, but it's also an opportunity to look at compliance in other areas as well, and especially these easy, basic topics such as producing an SPD. So I think those are good steps for you to take towards compliance at the beginning and as we move through 2014.
Thanks, Chris. I'm just going to look at a couple separate questions here. First, we did one question on the rollover, which may be more of a rollover question than a document question, but certainly related, and that is, does the employer have to take the rollover option this year or not, or is it an ongoing option, and what needs to be done with the document?
So the rollover is now law as long as there is no change to the law in any form. The rollover can be added this year for the current year, or it's an option going forward. So if the employer is not quite certain at this point if they want to add the rollover, certainly that's an option for next year in the future. The SPD does need to be updated, and it's pretty lenient. The SPD can be added at any time during the year from which funds are rolling over. So if you would like to add the rollover to the end of the 2014 year, you have until the end of 2014 to update your SPD. So it's fairly lenient in terms of when you need to amend the documents. So if you're still deciding, it's still an option to add for this year if you would like, but also in future years if you don't decide to add it now.
Chris, one good question we got earlier, and this I think speaks to some of the complexity right now surrounding healthcare reform and otherwise, is what is the difference between an SPD, summary plan description that we've been discussing today, and an SBC? Briefly, those are two different things. The summary plan description rules have been around for a while. Those are, SPDs are legal documents that govern the plan, and those requirements apply to basically any group health or welfare plan. Alternatively, the SBC, Summary of Benefits and Coverage, is a new, specifically starting at the end of 2011, a new healthcare reform requirement that was designed to be a simple statement and document describing the group health plan. So SBCs only apply to group health plans that are not accepted benefits, and they are different than SPDs. I would argue that the SBC is a superfluous document that's not needed, and is an excessive requirement of the Affordable Care Act, but it is a requirement nonetheless. For those that we administer HRAs for, since the HRA is a group health plan, we provide both the SPD and the SBC for HRA plans. Health FSAs do not need SBCs. Group health plans do, and most of the time for fully insured plans, the carriers provide them. So that was a very short explanation of a convoluted topic, but that's the answer there. Chris, second rollover question is, if the employer does not accept the $500 health FSA rollover and continues with the grace period, does anything need to be done with the documents, and is that a continuing option?
Assuming that the SPD and the plan documents already reflect the grace period, and the grace period is being administered for the plan, that nothing needs to be done to the documents. For the foreseeable future, grace period is still an option. It might get to the point, I know majority of the plans are adding the rollover. Will the grace period ever not be an option? I'm not sure. It's still legally an option, and it's still an option for plans that we administer for the time being.
Thanks, Chris. I've gotten several questions from our ProBenefits 125 clients that we administer either a premium-only plan or a 125 plan with FSAs. as to whether or not the Section 125 plan that SPD that we provide to clients serves as a wrap, the short answer to that is no. The documents that we provide for our clients are the plan document and SPD for the 125 plan, or in the HRA context for the HRA plan. That is not a wrap document. A wrap document would have to be a separate document. Now, a wrap document could incorporate the 125 plan as a benefit in the same way it would incorporate group health, dental, vision, etc. But just to confirm, even though the Section 125 plan does include pre-tax premiums for health, dental, vision, etc., it is not by itself a wrap document. A wrap document would be a formal legal document that would incorporate one or more benefits. So our goal for our clients, 125, 105, otherwise, is to provide quality, current, updated documents. For instance, a big project that Chris has done a great job with, he mentioned some of those updates for 125 plans, is going through all of our 125 plans and in early 2014 and looking at which documents need to be updated for that list of 5 items that he went through earlier. That's something we're going to do for our clients, is not only provide the document when the plan is instituted, but also keep that updated for you. And that's one of our promises as part of our administration. We are out of time, so I'm going to go ahead and close it down there. Some of you have submitted some questions, and I'll try to get to those shortly. For those of you that have submitted questions or have not, you're welcome to, if you got a couple of minutes, open up the question box there. You can even undock it from the control panel and expand it so you can see it, on a larger scale on your screen. And I've tried to answer probably 5, 6, 7 questions to the whole group so that you can see the question and answer there for some of the common questions. But feel free to submit a few questions. We'll hang on the line for a few minutes. But again, thank you for joining us today. We appreciate you being with us. For those of you that are our clients, we appreciate the opportunity to work with you. Chris and I are committed to the highest level of benefits compliance for ProBenefits clients and raising the overall level of compliance and education. So it's our pleasure to work with you. Thanks. Hope the rest of your day goes well, and we'll be in touch with a copy of the slides and also a copy of the recording of this session. If there's any specific topic that we covered today related to this, you're welcome to contact us either in response to the email we'll send you, or you can email Chris at christopher@probenefits.com. Thanks, and have a good afternoon.